Hello, everyone. Andrew Reed here, Juris Doctor and former LexisNexis head representative at the Florida Coastal School of Law. And we're going to delve into criminal law, Canadian criminal law exam prep by talking about sexual assault, its history, and its major cases. Let's get started with this criminal law study guide. So here we have sexual assault, which is covered in the Canadian Criminal Code, Section 265, 271, 273.1, 273.2, and 276. Historically, and this is prior to modern sexual assault reform, which is still ongoing, the twin myths dominated legal inquiry in court. So the twin myths are the misogynistic idea that a complainant's past sexual history is evidence that they are either less worthy of belief or more likely to consent to sex. So back then, marital rape was not a crime. Rape was only penetration, and it was heteronormative. So this will explain this a little more. Prior to 1982, the old provision in the code was a male person commits rape when he has sexual intercourse with a female person who is not his wife, A, without her consent, or B, with her consent if the consent, 1, is extorted by threats of fear or bodily harm, 2, is obtained by impersonating her husband, or 3, is obtained by false or fraudulent representations as to the nature and the quality of the act. And in this time, sexual intercourse was defined elsewhere as penetration, even to the slightest degree. And there was the corroboration rule in evidence, so that direct evidence from certain classes of witnesses was seen as unreliable, and their testimony would not be allowed without corroboration. And you can let your imagination wander as to the meaning of that. The doctrine of recent complaint, also from back then, historically, there's a belief that people who were sexually assaulted would report the crime quickly if they were telling the truth, so that the trier of fact, the jury typically, but not always, would draw an adverse inference from the fact that the complaint was not recent. Okay, pretty scary stuff. History often is. So let's talk about the sexual assault law reform of 1982. So in 1982, the code was amended such that there was a blanket exclusion of any evidence pertaining to the complainant's sexual history, which is the old Section 276 provision in 1983. So from the Seaboyer case in 1991, the majority of the Supreme Court of Canada held that the blanket exclusion of the complainant's sexual history prevented judges from weighing the evidence for its potential prejudicial versus probative value, and that this would in turn prevent an accused person from making a full answer in defense, which is a charter right guaranteed under Section 11D. And in Seaboyer, they're saying that the judges here, there might be some probative value to the complainant's sexual history. In other words, there may be exculpatory evidence that is automatically excluded because of the nature of the offense. And the Judge McLaughlin wrote that the purpose of the legislation is laudable, but its effect may be deeply problematic for the purposes of an accused right to have a fair trial, presumption of innocence. Balancing a couple of factors here, tough job of judges sometimes. So the Parliament actually responded to Seaboyer in December of 1991, and they amended Section 276 to reflect the judgment in Seaboyer. So judges now weigh the probative and prejudicial value of the evidence of the complainant's sexual history. And sex assault is now part of assault simpliciter in the code. So in other words, it's an assault with an added circumstance of sexual nature of contact. Okay, and the code was again amended as recently as June 2019 from Bill C-75. So reform is ongoing here with sexual assault offenses. With sexual assault offenses, actus reus is conduct plus circumstances plus voluntariness. So with voluntariness, you're going to take a look at automatism and NCR defenses as well as traditional voluntariness. For conduct, you're looking for applying force, directly or indirectly. So Section 265 for all assaults, a person commits an assault when A, without the consent of another person, he applies force to another person directly or indirectly. Assault is also, from Section 265B, threats where the accused makes the complainant believe that the accused has the present ability to effect his purpose. Threat of assault, imminent danger. Section 265C, begging or accosting another person while openly carrying a weapon. So, implied assault. Section 271, everyone who commits a sexual assault is guilty of a hybrid offense. Okay, the circumstance will be another person. That's from the Rizzo Shoes and from the Chase case. Then the circumstance must also be the sexual nature of the contact. So this was covered in the Chase case, where they said the sexual assault is an assault within any one of the definitions of the concept in Section 265 of the Criminal Code, which is committed in the circumstances of a sexual nature, such that the sexual integrity of the victim is violated. So the test for sexual nature of the circumstances is an objective test. Viewed in the light of all the circumstances, is the sexual or carnal context of the assault visible to a reasonable observer? There's a non-exhaustive list of factors from this Chase case. The Chase factors: part of the body touched, nature of the contact, situation in which the contact occurred, the words or gestures accompanying the act, all the circumstances surrounding the conduct, including threats or force, the intent or the purpose of the person committing the act. And this is relevant, but it's not essential. The motive of sexual gratification may be useful, but it is non-determinative of whether an assault is sexual in nature. And that is a non-exhaustive list of factors, so there could be more as applicable. The KBV case of 1993 was the first to apply these Chase factors, and they stated that it was clearly open to the trial judge in this case to conclude from all the circumstances that the assault was one of a sexual nature, because in that case the assault was one that the sexual integrity of a child was violated. What matters, as they said in KBV, is whether the victim's sexual integrity or autonomy is interfered with, rather than any subjective belief the accused may have had with respect to the sexual or asexual nature of the contact. That's irrelevant. Okay, so another circumstance is lack of consent, or consent is vitiated. So consent must be freely given and contemporaneous. So from the Ewanchuk case of 1999, the absence of consent is subjective and determined by reference to the complainant's subjective state of mind. The complainant either consented or not. There is no third option. Section 273.1 says this on consent, that it's voluntary subjective agreement of the complainant to engage in sexual activity. So consent must be willingly given, ongoing, and communicated. So vitiated consent equals no consent. So the complainant survivor may or may not believe subjectively that they were consenting, but their consent is vitiated as a matter of law for policy reasons related to public safety and ensuring that the accused persons are not unjustly able to escape criminal liability. So here's some circumstances here. Age. Can't consent if you're not old enough to consent. Section 150. If someone else consented on the complainant's behalf, can't be done. No consent. Section 273.1 2A. Capacity. So the complainant is incapable of consent by reason of disability or unconsciousness. So RVJA, and also from Section 273.1 2A1. So in RVJA, in the Supreme Court of Canada 2011, a person cannot consent to sexual contact in advance, ever. And they also cannot consent in advance to sexual contact that will occur while they are unconscious. So consent needs to be contemporaneous at the same exact time as the act, not in advance, because Parliament has crafted the criminal code provisions to ensure that people are able to withdraw consent at any time during an encounter, which would be impossible if a person was unconscious. Non-trivial bodily harm from the Jobiden case of 1991. So the limitation demanded by Section 265, as it applies to the circumstances of the appeal in this case, is one which vitiates consent between adults intentionally to apply force, causing serious hurt or non-trivial bodily harm to each other in the course of a fist fight or a brawl. So the court notes that further limits on consent to bodily harm should be decided on a case-by-case basis where the facts are different. But lower courts have nonetheless applied Jobidin to sexual assault, where you cannot consent, so they said, to non-trivial, non-transitory bodily harm. Okay. Position of trust, power, or authority. So Section 273.12c, Section 265.3d, when you're in this position, then consent is no consent. Application of force to the complainant or to a person other than the complainant, Section 265.3a. Threats or fear does vitiates consent. There is Section 265.3b. Fraud, Section 265.3c. So HIV non-disclosure, sabotaging birth control, fraud as to the identity of the sexual partner, fraudulent sexual contact under the guise of gynecological or medical services, fraud as to the sexual nature of the contact. So this will can use the Courier test to determine whether fraud applies here. So you have a dishonest act, which is a falsehood or a failure to disclose, something like HIV status. And then you have deprivation, which is denying the complainant knowledge that would have caused him or her to refuse sexual relations that exposed him or her to significant risk of serious bodily harm. So in the Courier case, 1998, consent can be vitiated by fraudulent non-disclosure of HIV status. Complainant does not have the opportunity to withdraw consent with full information, and there's a risk of serious bodily harm because of the sexual activity with the accused. From the Mabior case of 2012, another HIV non-disclosure case, significant risk of bodily harm is defined as somewhere between no risk and high risk. Okay. In other words, a realistic possibility of HIV transmission where Mabior does not use condoms and does not have a low HIV viral load. The question of viral load becomes important nowadays with robust antiviral medications, or so that was stated in Mabior. In Hutchinson, 2014, sabotaging birth control interferes with the complainant's sexual autonomy, and there is a risk of serious bodily harm because of the physical and emotional consequences of pregnancy on a woman's body. So the concept of bodily harm includes such profound changes in a woman's body as those resulting from pregnancy. So where a complainant has chosen not to become pregnant, deceptions that deprive her of the benefit of that choice by making her pregnant or exposing her to an increased risk of becoming pregnant by removing effective birth control may constitute a sufficiently serious deprivation for the purposes of fraud, vitiating consent under Section 265.3c. In other words, no consent. Okay, mens rea here is a subjective standard plus an objective standard for the element of consent. And this comes from the Iwanchuk case. The mens rea for sexual assault is the intention to touch and knowing of or being reckless or willfully blind to a lack of consent on the part of the person touched. So the accused must have the following mental state for the Crown to make out the elements here. The accused intended to touch the complainant, and the accused knew or was reckless or was willfully blind to the fact that there was no consent on the part of the complainant. So note that those need to match. So that's an and element. Section 273.2, the accused did not take reasonable steps to ascertain consent, to get consent, or complainant's voluntary agreement was not affirmatively expressed by words or conduct. So the Crown can show that the accused knew about or was willfully blind or reckless as to the absence of consent by showing that the accused did not take reasonable steps to ascertain consent or show that the complainant simply did not communicate consent. Like this video, hit subscribe, hit that notification bell for more videos on Canadian law.